Good afternoon. Hello, hello. Good afternoon. Let me try again. What are you all here for anyway? Great to see old and new faces. I want to get started because I know there's going to be a lot of great discussion, and I want to make sure we can take advantage of it. So greetings, I'm Karen Ingle. I teach here at the law school, and I co-direct along with Neville Hode, who's playing a double role today, the Rappaport Center for Human Rights and Justice. Welcome to our second event in this year's semester-long colloquium on reproductive justice, criminal law, and the carceral state. I'd like to begin by acknowledging that we're meeting on the indigenous lands of Turtle Island and acknowledge the American Indian and indigenous communities who've been or become a part of the lands we call Texas, including the Alabama Coushatta, Caddo, Carrizo Como Crudo, Coahuiltecan, Comanche, Kickapoo, Lipan Apache, Tonkawa, and Isleta del Sur Pueblo. So as many of you know, this colloquium is part of the Rappaport Center's Sissy Farenthold Reproductive Justice Defense Project, led by Blake Rocap and Cristina Ramirez here. We're delighted today also to have the co-sponsorship of the Lozano Long Institute for Latin American Studies. Now I'm looking around. Some of you are here with Lilas, and also the Latin American Initiative here at the law school. The colloquium is also part of an interdisciplinary seminar that Blake, Cristina, and I teach, co-teach to roughly, and with the people at these two tables, who are the students in the class. They've read the work of Professor Jaramillo, and have also written some papers or short paragraphs on that work, and they'll have a chance to ask the first couple of questions today, but there will be an opportunity for everyone to engage. So with that, it's my enormous pleasure and honor to have with us today Isabel Jaramillo Sierra, who is professor of law and director of the jurisprudence department at the Universidad de los Andes in Bogota, Colombia, where I've had the good fortune to spend a significant amount of time and talk to Isabel about many things, but not much about abortion. So this is a great opportunity. She will discuss her paper, The Decriminalization of Abortion in Latin America, Old and New Feminisms in the Region, which focuses on the decriminalization of abortion in Colombia, Mexico, I guess I should say Mexico. If I'm going to do it, I should do the accent right, and Argentina. She's written extensively on feminist legal reform, with particular attention to quotas, abortion, and violence. And on abortion alone, she's authored or co-edited, I don't know how many books. 3, okay. Beginning in 2008, following a constitutional court decision that she'll talk about, and then up until most recently in 2021, La Batalla por el Derecho al Aborto. So the battle for the right of abortion, and then it goes on with the subtitle. As you'll see today in her presentation, Professor Jaramillo works with feminist scholars throughout Latin America, and she'll be talking a bit about that, I think, and some similarities and differences among them. She acts as general coordinator of the Latin American Network of Feminist Legal Scholars, but she's not just an academic. She's also worked as a consultant on gender and human rights for various governmental bodies and has served as an ad hoc judge for the Constitutional Court and the State Council. And her official bio says, and I think there must be some reasoning behind saying this, that she was nominated for but didn't get an appointment to the Constitutional Court of Colombia. So I don't know if that's by President Santos. I don't know if that's an accolade, but we'll treat it as whichever part of it you want to treat as an accolade. So after Professor Jaramillo speaks, we'll have the opportunity to hear a response from my co-director at the Rappaport Center, Neville Hode. He's also a professor in the English department and is affiliated faculty member of the Center for Women's and Gender Studies. We asked him to respond because he's written about human rights movements quite a bit, similarities and differences in Africa particularly, but not only in his native South Africa. He has a book forthcoming, yay, entitled Pandemic Genres, Imagining Politics in a Time of AIDS. So we're in for a great presentation, response, and conversation between them and among all of us. And so with that, thank you so much for being here, Isabel.
Thank you very much. Good afternoon, everyone. And a special thanks to Professor Engel and the Rappaport Center for the invitation, and the students who read the paper and have discussed it. And this is like the second time they'll be hearing about it. So really, thank you very much. And so my presentation today is going to focus on the strategic work deployed by Latin American feminists for over 30 years to achieve the liberalization of abortion laws in the region. In particular, I would like to contest the idea that changes in abortion law mostly resulted from a short-lived green wave that shook political establishments so hard that it surrendered women's reproductive freedom without much resistance. This image, I believe, places the guilt of counter-reform on feminists who were not able to spark massive mobilization in their countries, and makes invisible the enormous efforts invested in incremental change over the last 30 years. Also, it betrays the huge efforts made to take law seriously and not as a talisman that can magically change lives overnight. I will use the cases of Mexico, Colombia, and Argentina to illuminate three characteristics of this strategic work. First, the belief in incremental change. Second, the confidence in rights. Third, the transnational nature of work. I refer to this type of feminism as old feminism for two reasons. First, because it works on the framework agreed upon on the Beijing Conference on the Rights of Women in 1995. This comprehensive set of goals called for an increased participation of women in decision-making positions, the redistribution of wealth and income among men and women, and the reduction of violence against women, and an ample understanding of women's rights as human rights. And second, I also call it old feminism because most of the women leading these strategies are in their 60s and 70s, soon to retire from their jobs at the NGOs they established in the 1990s. So it is both about a set of ideas that have been under a lot of scrutiny over the last 30 years and generational. I contrast this old feminism with a new feminism that aims at more radical changes, uses direct action, and works locally. This is the feminism of Me Too, that in Latin America was mostly a movement of university students that demanded authorities to take actions against professors that for years have been abusive of their power and used sex as a coin in academic exchanges. In Latin America, it was ni una menos, ni una más, un violador en mi camino. These are younger women using social media, closing down universities, burning buildings, and writing graffiti to reclaim public spaces, express rage, and in some cases, get satisfaction. For this, to speak of the strategic actions of feminism, of feminists, of the old feminists, I would like to start by telling a story of abortion rights reform in Mexico, Argentina, and Colombia that starts in 1999 with a strategic litigation of the Paulina case in Mexico and ends in 2023 with the decision by the Mexican Supreme Court declaring that the criminalization of abortion in the early stages of pregnancy is unconstitutional and demanding changes in the criminal codes of the states where this was not yet the case, where the states in which it was still a crime. I will show how these efforts aimed first at the implementation of the indications already established in the law, and then at introducing authorizations for the first trimester. I will also show that they focused on consolidating a rights discourse in the highest courts, including the Inter-American Court of Human Rights, that would stabilize what they achieved and provide grounds for legislative work and posterior litigation. Finally, I will highlight the importance of building bridges between this old feminism and the new feminists. Okay. So the cases. In 1991, Paulina, a 13-year-old girl, was raped by strangers in front of her relatives. And although the doctor and the hospital found that she was clearly included in the exception established in the law of Baja California for cases of rape, she was not able to get an abortion because her mother was wrongly admonished of the irreversible damage that the procedure would cause her daughter. This counseling came from the hospital director, who should not have been providing these recommendations. Paulina gave birth, but her case was litigated to obtain reparations for the damage caused by the hospital director that provided false information to the mother. The case was brought before local judges and finally reached the Inter-American Commission of Human Rights in 2006, with little consequences. The injustice of the case, however, as it was perceived by the general public, after over more than 6 years of litigation, was useful in mobilizing the leftist mayor of Mexico City to ask the local legislature to change the law to allow abortions in the first 12 weeks of pregnancy. The law was approved in 2007. 1 month after the approval of this law, the Supreme Court of, 1 month after the approval of this law, it was challenged before the Supreme Court by the federal legislature. The court, in a much criticized decision, simply explained that local legislators were free to choose the ways in which life before birth would be protected. It did not mention women's rights or balance in any way the state interest in preserving life before birth. And this is why it was criticized, because the court, while allowing the new law to prosper, didn't say anything about women's rights. And so the goal of not only getting incremental change, but also securing the rights in constitutional discourse was not achieved. So from 2007 to 2020, feminist NGOs or Mexican feminists worked to get the Supreme Court in Mexico to say that it was a right of women to get an abortion, at least within the first weeks of pregnancy. And this they achieved in 2020. In 2023, the Mexican Supreme Court finally said not only that women had a right, but that it would be unconstitutional to pursue the protection of life from conception by criminalizing abortion in the first weeks. So we started in 1999 with a young girl who clearly was under the exception. Her medical doctor clearly understood that she had a right to an abortion under the exception in the Baja California law, but still could not get the abortion that she was asking for. And we get to a decision by the Supreme Court in Mexico saying every state has to decriminalize abortion. So this is the case in Mexico, and I would be happy to get a little bit more into it. I'm not a Mexican. I'm not that expert in the different pieces of the puzzle, but I would be glad to just go into each one of these cases if you have questions. Then in Argentina, where we have the images of the green wave, it was the most famous images because it was really, really a multitude. There were millions of people in the streets asking for abortion, first in 2014 and then in 2020. The part that usually doesn't come out is that this green wave was preceded by litigation before the courts. So Argentina, just as Mexico, already had indications or exceptions in the law. But the indications were interpreted in such a way that very few women could have access to legal abortions. So in Argentina, although a federation, the criminal code is national, so it applies to every one of the provinces. And the criminal code stated that women who had a cognitive disability and had been victims of rape or whose life was at risk could get an abortion. Or at least this was the interpretation by most medical doctors and lawyers, was that you had to, the exception was only for women who had a cognitive disability. And on top of that were victims of rape and or had a medical condition. So what the feminists did was to unpack that exception so that all women, and not only women with cognitive disabilities, could access the exceptions for rape and a condition threatening the life of the mother. And they did this through a case that came to be known as the FAL case, or F-A-L case, in which there was, again, a young woman who had been raped by a family member in this case, who went to the hospital. The hospital claimed that they couldn't provide the abortion unless there was a judicial decision acknowledging that the exception was present, and they went to the first judge, who found that it was not the case, that she could not have a legal abortion. But then they went to the tribunal. The tribunal agreed with the feminists that the code should be interpreted extensively. And this woman, as opposed to Paulina, she was able to terminate her pregnancy. And the case continued to the Supreme Court of Argentina, and the Supreme Court finally said, well, it is true that the exception has to be interpreted widely, so to extend or extensively to include all these other women. Now that 2012 case, which was won in one of the most conservative provinces in Argentina, paved the way for a mobilization in high schools and in different places of the country, that then was used by legislators in 2014 to attempt a first change of the laws in Argentina. They failed to reform the law in 2014, but then they tried it again in 2018, and in 2020 the criminal code was finally repealed and changed by one that established a 14-week exception for women. So, and I was commenting today at lunch that in Argentina, it's true that there was these huge mobilizations, but it's also true that the people mobilized in a very specific strategy to put pressure on the legislator. So it was the people who had initiated the Ni Una Menos mobilization against violence against women, the femicides. They convoked these marches on the particular days in which the legislator would be discussing the law. So it wasn't like going out on the street on any day or any, commemoration of. It was in particular to sit outside of the place where the legislator was discussing the reform, to put pressure and obtain the result that they wanted to obtain. Okay, so Colombia is the case in which there has been the least mobilization. So very far from the masses in the streets, not strategic, not even, even when the feminists have wanted to have people in the street, they have not been able to bring the people out in the street. Nevertheless, the feminists have achieved to liberalize abortion up to the 24th week. So we have Mexico City, 12 weeks. We have Mexico, early stages of pregnancy, Mexicans still don't know for sure what that means, whether that would mean 12 weeks, 14 weeks, or 16 weeks. I would say go for 24 weeks, but anyway. The Argentinians have 14 weeks, and Colombians have 24 weeks. And this was, again, without having people in the streets. And it was all through strategic litigation before the Constitutional Court. We have very particularly democratic procedural rules that allow any citizen to claim before the Constitutional Court that a law is unconstitutional. So this was the first step, just going as citizens, individual citizens, to claim that abortion law was against the Constitution. And that was in 2006. That was the initial strategy, and that was one. And they initially claimed that abortion as a crime was against the Constitution as a whole, and the Constitutional Court said, not really, we're only going to give you 3 exceptions: life, fetal malformation, actually fetal unviability, rape, and incest. And the feminists in 2006 were, they had to make some lemonade from what they had gotten from the court. The court had previously, in 2 occasions, said, no, the law is okay as it is, which meant that it was okay with no exceptions. There was one decision from 1994 and one decision from 1997. And so to get these exceptions was deemed a lot, although it was already very clear that there were going to be very few legal abortions. So for the next 15 years, feminist organizations tried to increase the number of legal abortions, mainly by teaching doctors that risk to life meant risk to health, because life should be interpreted as good life, not as any life, but as dignified life, as the life we want to live. And if life is the life we want to live, it should include health. And health is the best state of well-being that one can aspire to, and it's not only the absence of disease. And then they supported these claims using international law, using documents from the World Health Organization, using constitutional law, Colombian constitutional law, comparative constitutional law, trying to show that health should encompass this state of well-being. And they did manage to increase, let's say for the first years, the total number of legal abortions was around 1,000, in a country where it had been estimated that there were 450,000 abortions per year. So the first years we had 1,000 legal abortions, and then it went up by some estimations to 10,000 or 12,000 under these extensively interpreted health indication. What happened in between, I would say, 2018 and 2022 was that feminists started to gather information about criminalization of women in Colombia. So the general public was under the idea that no women were being prosecuted for abortion anywhere in the country. And what the statistics from the General Attorney's Office started to show was that there were indeed women being sentenced for abortion, but the sentence was so small that none of them was in prison. No women went to prison. And Professor Engel has been insisting, we have to find out what happened to these women. We don't know what happened to these women. The data from the General Attorney's Office doesn't allow us to identify them, so we will have to find them. But actually, so this is part of the story. But it's still, for the Constitutional Court, it was persuasive enough to know that even under the indications framework, there were so few abortions, and there was prosecution, criminal prosecution. That was intensified because we had proof that it had grown, that the number of cases prosecuted had grown, and there was also proof that and I read like 2,000 of those cases, that the people who were reporting the women were the medical doctors, nurses, and social workers at the hospitals where women were arriving with obstetric emergencies, right? So miscarriages and other unsafe situations. And, when they were arriving to the doctors, the police was being called on them. There were even reports of policemen waiting outside of the emergency room to handcuff the women, etc. So so there was no prison, but a lot of state violence and police brutality. So that was enough for the Constitutional Court to finally say, well, this is not working. So the framework with the exceptions is not really working to guarantee women's dignity. And so we will extend we will create an authorization up to week 24, and after week 24, we will keep the exceptions. Okay, so these are the cases. Now, and I hope I showed how they were incremental, strategic, persistent. Okay, but you'll let me know how persuasive I have been up until now. Now, they've also worked in a transnational, very aware of the importance of transnational work. And this transnational work has two types of, two fronts. One was a political front, and the other one was the legal litigation front. So on the political front, these feminists that I have called now the old feminists, created since 1981 an institution, the Latin American Caribbean Feminist Encounters. They meet roughly every 2 years to share their experiences, their strategies, to talk about their agendas and their progress, and they know each other and they can rely on each other throughout, the years that they don't meet. So I think that's one important scenario, and I appreciate very much what that has meant for Latin American feminism. If anyone wants to go further into it, I'm happy to oblige. But then there's the litigation. And so they started to litigate really intensively before the Human Rights Committee. There was one case from Peru and one case from Argentina. And before CEDAW, there's one case from Peru again, and also before the Inter-American Commission, and finally before the Inter-American Court of Human Rights. I would say, because now I see that my time, I'm going, I have 10 minutes. Yes, Karen? Okay. I would say that, and in this I have to, I didn't trust this particular litigation, but then it has proven to be quite important. So in the Inter-American Court of Human Rights, the most important step was the decision in the Artavia Murillo case, Artavia Murillo versus Costa Rica. That was a case on in vitro fertilization. And it became very important because in that decision, the court upheld the possibility of in vitro fertilization against the argument by Costa Rica that because the San Jose Convention on Human Rights protected life since conception, discarding an embryo for a treatment, an in vitro fertilization treatment, meant disregard for the right to life, and therefore in vitro fertilization should be forbidden. So this was the argument by the state of Costa Rica was that the loss of any human life after conception was against the San Jose Human Rights Convention. And the Inter-American Court said, no, actually, the convention does say that human life will be protected since conception, but that is only a gradual protection, and states cannot or this right to life from conception cannot trump every other right. In particular, in the case at hand, that it could not trump the right of people with fertility disabilities to bear children, and so that Costa Rica was wrong in its interpretation of the convention and therefore should change its law and authorize in vitro fertilization. And so this case then became cornerstone in attacking the strategy from conservatives in Mexico that thought that putting into their constitutions the right to life from conception would stop any attempt at liberalizing abortion. It has also been very important in the cases of Manuela against El Salvador, and more recently, Beatriz versus El Salvador, which has not been decided yet, but I actually think it's very hard for the court to say anything different than abortion. I mean, the prohibition of abortion in every case is against the Human Rights Convention. And if anyone wants to know more about the Beatriz case, I'm happy also to expand more on that. Okay, so this is a transnational work, and it's in some cases it has not been that relevant. For example, Peru has two cases, one before the Human Rights Committee and one before CEDAW, and Peru has not been able to move ahead in the liberalization of abortion. They're really stuck in a very bad place. I really don't understand well why, but that's what's happened in Peru. And in Colombia, there were no cases litigated before international instances, and still they were able to proceed rather quickly with liberalization. Though one would have to mention that in every decision by the Colombian Constitutional Court, international law has been crucial in arguing that women have a right, that there is such a thing as sexual and reproductive rights, that Colombia is a signatory to all these international conventions, and so that, you know, all this is important in interpreting the Constitution, and therefore that, you know, international law plays a role. Not such a big one as in Mexico and Argentina, but it is there. Okay, so the new feminism, right? So this, I hope that I was able to convey an image of this old feminism, something short about the new feminism, and just as a, you know, to have something for a polemic, I guess. So images of young women taking the streets in Latin America have been more and more abundant in the last 10 years. These women, under like different slogans, have expressed rage before institutional inaction in the face of violence against women, and demanded changes in legislation, bylaws, and disciplinary decisions. These women can be credited with the introduction of femicide as a crime, with an increased sentence, or in some cases, femicide as an aggravating circumstance for homicide. Equally important was the mobilization surrounding Un Violador en Mi Camino in Chile. Less visible, but also important, have been student mobilizations in Mexico, Chile, Colombia, and Ecuador that have demanded the enactment of disciplinary bylaws to investigate and sanction sexual harassment in public and private universities. The young feminists making these new demands have been quite hostile to the older feminists' call for institutional action and strategic litigation. They are convinced that incremental change is a farce, an excuse to maintain the status quo. They denounce the old feminism for not working hard enough to achieve justice for poor and racialized women, and for opposing the imbrication of the LGBTQ+ agenda in feminist mobilizations. Old feminists, on their part, treat the new feminist claims as debilitating and ill-informed, and accuse the young of lacking in their political awareness. I believe the Chilean case in some ways invites a reflection on how to bridge gaps between the old and the new, showing the importance of grandiosity in the face of historical injustices, but also the need to work pragmatically towards the achievement of these goals. Chilean new feminists indeed worked very hard to include gender in the agenda of the structural change that the country needed to undergo to overcome the legacy of Pinochet's regime. They were adamant in demanding parity in the Constituent Assembly and would not accept less than including the right to have an abortion in the draft constitution. They won these battles, but they lost the war. Instead of focusing on the constitution that could be approved, they focused on the constitution they wanted. A lot of energy was lost in drafting and then voting. The movement was debilitated, and the results could not be used for any other purposes. And I think so I think that the Chilean case is interesting because they did set up like these standards of what should be any constitutional process in the region. But it also seemed, I'm not saying that the constitutional effort in Chile failed because of the feminists and what they asked for. No one in Chile would say that it was because the right to abortion was in the Constitution that the constitutional process failed. This is not something that is discussed. But the fact that they did get to have the right to abortion in the Constitution didn't mean much in the end, right? They couldn't get the Constitution to be approved. So the Constitution, with all these women in the Constituent Assembly, could not pass the test of the majorities in the vote in the street. I don't know if you're all familiar with what happened in Chile and the failed constitutional reform, and I'm happy also to go more into that. And so the feminists could not have, they didn't have a plan for the Constitution to be approved, so they lost the Constitution, and I don't think they won much in terms of the right to abortion, because in terms of the right to abortion, they still have the law that has very few indications, has a very ample conscientious objection. So in Chile, hospitals can claim to have a conscientious objection, and the hospital itself, not individual doctors, but the hospital can deny service to individuals. So this type of, the fact that they were present in the Constitutional Assembly, the fact that they were able to put it in the Constitution has not meant anything with regards to the laws that still exist in Chile. So I think that it was very important that the feminists showed that this is what we should be asking for. But then the lesson is, so what if we get this, but we lose everything else, right? So I think that's an interesting reflection for us in Latin America. Now, as to the lessons for the US, that's something I have like a little paragraph on that. I'm very hesitant about it, so I'll let Neville go ahead, and then all the questions. I'm sorry? Should I go? So it's only a paragraph. I'm very hesitant about this. But I think that on the one hand, from far away, Roe versus Wade always seemed like a very grandiose baseline. It was very criticized by local feminists because it was based on privacy and not on equality, and therefore it excluded many women from the possibility of having a safe and legal abortion. But from afar, it was perceived as there was all this that you could have worked with, right? So you already had like a very ambitious baseline, just to say that. It was also, from the story I know, it was preceded by very radical mobilization. So in the 70s, women were like really mobilized and had lots of confidence in the future. So these feminists in the 70s, I would say, in many ways are like the new feminists, like very ambitious, with very high hopes of what could be done. And I think they did win, right? So Roe versus Wade. I think that the American feminists, but I say this again with they seem to have been less cautious about the law and the importance of expanding what they had obtained. It seemed that their attitude was defending, Roe, instead of bringing Roe to more people. It might be unfair. I think as scholars, many wrote on the need to expand Roe, and I'm not sure what happened at the level of litigation. But I have read, there's not a lot written on the women who were actually excluded and the ways in which they were excluded, but from what I have read, there was some room to wiggle, and probably there was not enough done in that sense to include these women into the movement, etc. But also it would seem, again, hesitant, that from the work of the old feminists in Latin America, that centering too much or only on abortion could be a mistake, right? So that you need to have other major points in the agenda for any change in abortion to be fruitful. So political participation, so Argentinians had quota laws since the 1990s, Colombians had quota laws since the 2000s, Mexicans had women in politics since the 2000s with so this was like big changes. They also had clauses in the Constitution about women's equality. This happened in Argentina, in Colombia, in Mexico, in Bolivia, in Ecuador. There was all this work also on violence against women. I know in the U.S. also, and I think it's unfair to say that there was no work done. But then the reversal of VAWA in the 2000s was already like this big signal for many, I know, that, it was going to be very hard, right? So Dobbs is like one piece of major building. So these are a few thoughts. I don't know. I'd be willing to go more into my own thoughts, but this is all that I had for now. Thank you.
Okay, wow. Thank you, Professor Jaramillo. It's great to see all of you. As you probably know, I'm not a lawyer, but that never stopped me from having a few opinions about the law. One of the things that I really loved about the paper, and I'm a little bit upset because you answered my one big question already, so I'm going to have to try and rework that big cluster of questions, is that it shows the enormous value and difficulty of doing comparative work. And it's both national, regional, there's geographic comparison, but there's also in the new old feminisms the great difficulty of doing historical or temporal comparisons in actually trying to, and then there's also like where does abortion fit in wider feminist struggles. So we've got the comparison between what I think we would now call intersectional feminism or single issue feminism. And we're also in multi-sectors. And we're also in the imagining of law, we're in the relationship of law to social movements. So I think the sort of nuanced, multi-scalar, multi-sector comparative analysis can teach us a hell of a lot. And the first thing it teaches me, which makes me very happy, is that actually neoliberal rhetorics of best practices we can just throw out the window. Because actually we need to know the specificities of a place, we need to know the history of the strategies that have worked in that place, we need to know legal histories, social histories, as well as seeing how these things hit the transnational. So sometimes the transnational works, sometimes it doesn't. I also liked all the moments where you hit those big UN conferences on women, because one also sees that actually these sometimes state level, sometimes country level, sometimes regional level, are also interfacing with a global movement. So you demonstrated for us the model of erudition that one needs to get this analysis started. And it's exhaustive and I imagine exhausting. But thank you, because I think, and then at the end when we add the US in, where it looks like we're going to have to flip it all around, the comparisons get even more pointed and difficult. But I'm going to ask at the end about the League of Caribbean and Latin American feminists, because that also looks like a place where, despite all these difficulties around comparative analysis, we can think about solidarity in more responsible and more useful ways. So my second, so there's a cluster of questions there around the difficulties and opportunities of working comparatively. My second question you kind of answered. I'm a little bit anxious about the answer you gave, even though towards the end you complicated that answer. Okay, I'm an old person. I don't want to think of myself as an old feminist. I mean, the old feminists to me are like, I don't know, Betty Friedan, Gloria Steinem. They're people like my mother's age. And so I understand why. I mean, and actually, I think you're right, because we're in human time. We're in generational time. But I also want us to think about the time of historical memory. And I think, for example, okay, is Madison here? Okay, Madison gave a wonderful presentation in the Rappaport Center Human Rights Team meeting, where she showed pictures of the women in the white headscarves in the protest against the disappeared in Argentina in the 70s, and how that's echoed by the women in the green headscarves, and how iconography is borrowed across generations in imagining like the long arc of certain forms of feminist struggle. So, and you say this at the end, actually, we're talking about mass mobilization, that the new feminists are like the old feminists. And I mean, this is part of the Sissy Farenthold talk. And I mean, Sissy was a young feminist and an old feminist. And we did a big project on disarming toxic empire, where we tried to imagine how contemporary environmental justice movements could learn from, let's say, the campaign against nuclear disarmament. So there's generational memory, and there's also historical memory, and I mean, and that's where it gets pedagogical for me. And I could tell trashy stories, like my students think about Madonna the way I think about Betty Grable. And to a lot of you here, that'd be the same unintelligible person. But so it's just like, so how do we stop reinventing the wheel, and how do we sort of think about this question of old, new, generational, intergenerational, and the mobilization of historical memory in these battles? I'm going to say a little bit. I didn't plan to, but since you ended kind of with constitutionalism, and I'm going to be a horrible constitutionalist cynic. Okay, South Africa's constitution in 1996 was widely heralded as the most progressive gender and sexuality constitution in the history of the world. Okay, I'll be a nationalist for a moment. It had a great equality clause. And I remember for a decade afterwards, I would go to international academic conferences, and there would be this totally schizophrenic representation of South Africa. Great, great constitution, some of the highest levels of gendered and sexual violence in the world. So, I mean, I kind of think constitutionalism for me is sometimes the illegal equivalent of trickle-down economics. Is I don't actually see it working. So I'm sad the Chilean constitution, they didn't get that great constitution. But even if they'd gotten that great constitution, I don't necessarily think a constitution is not sufficient for creating equality, gender justice, etc. I love the mobilization of the right to dignity in here. And also the remarks about like life, good life. So that they're kind of normative imaginings of the law that extend, if you like, beyond the letter of the law. So I don't know how to connect that with the historical periodizing, but I think it's got to do with memory, and it's got to do, okay, this will bring me to my third cluster of questions, which is the buried language of affect or feeling in this. I loved when you talked about friendship. It's a brief moment. You end the paper on, I think, emotional and resource drain. like in 10 years, I will remember the comparative brilliance of this, but I will remember those cases because they're such poignant stories. And I'm sure they were cynically selected for their affective power and the sort of sense of outrage that what happened to these various women who were multiply victimized and harmed. And you said the word public outrage. So I don't know how one puts that sphere, if you like. I mean, there's been a lot of recent, very interesting work on the role of feelings in social movements. And the law likes to pretend it has a cold eye. But it's actually, I think, a deeply sentimental and emotionally saturated, almost oversaturated way of doing politics. And so I'd just like you to talk a little bit more. I mean, the right to dignity in South Africa, that's one of the places where the Constitution was given good life. So it gets deployed in housing cases. It just gets deployed in sanitation cases. It actually gets deployed to do a whole lot of work around, second-generation economic and social rights. So I have a question about what my friend and colleague Anne Svetkovich would call public feelings. So what can the law do, particularly around questions of gender justice? And abortion itself is such an emotionally saturated terrain. So I'm going to do my quick trashy periodizing of American feminism, which is, I'm sorry for those of you who know anything, it's a series of cliches. And it's interesting, it doesn't do it in old and new, it does it in the language of waves. So it's sort of in that concept metaphor, you've got rise and fall. So, okay, there's first wave feminism, which is like 100 years ago. And that's around suffrage, that's around basic political and civil rights. Then there's second wave feminism, which I would argue gives rise to something like Roe v. Wade. I mean, it starts off as sort of bourgeois, problem with no name, white lady feminism, but it becomes much more. And then there's third wave feminism, which I could ask some of the students here to explain, but I suspect you're already too old, which is actually the shift from the language of women to gender, a reaction to the sex wars, it's the introduction of LGBTQ issues. And then there's Me Too. And I would actually say I don't know if I would call Me Too fourth wave feminism, or if it's a return to actually like a much simpler, unintersectional analysis. Okay, we had a nasty sexual harassment case in my own department several years back. And I remember the women students of color saying to me, we don't care, this is a white girl issue. And I was sort of stunned by that, but it was, that was the framing. So I think, and I think certain parts of second wave feminism in the US were intersectional before intersectional was a word. So I'm thinking of, Sissy Farenthold and the Women's Peace Summit, or the anti-imperialist commitments of, and I don't know where I would fit that in, but I'm just thinking about how do we mobilize your historical narrative? And I'm sympathetic with the fact that you're strongly in the time of a life, because that's what we have. But I think these issues extend deeper in time. And if we want to talk about the United States, and I've talked a little bit about South Africa, they also have an incredibly uneven geography. Mm-hmm. Okay, I'm starting to ramble. So I just want to thank you. That was really, really wonderful. And I'm sure we all learned a lot from it. And I think you can come back up here and take questions from the floor. Or do you want to take it from there?
A couple of things, and then we'll respond.
Respond. So yeah, I struggle with the comparative. I've been in the last 6 years, so since 2004, I've been a part of a network of feminist law professors, and in the last 6 years, I've been the coordinator of that network, and that means that every day I learn about Mexico, Argentina, Guatemala, right? So I'm in a chat with law professors in this country saying, you know, Isabel, I'm sorry, I can't send you the chapter I promised because, I don't know, there's this drought and we can't drink water and the president just said whatever. So it would seem we don't have, it's not a chat about politics, it's only about scholarship, but then for everyone, politics is just like shapes their lives in such an intense way, right? So Congress is going to vote this law, so I can't, you know, I have to be there all night, and I can't send you the paper. So I've you know, so I kind of feel that I live and breathe the comparative. Then again, I've studied, you know, methodologically what it means, and so I struggle with not becoming paralyzed in front of the call of the context. But then trying to be honest with the context and how it defines what's going on. So, yeah, thank you. I will think more about these elements of the comparison. What are they saying? As to the historical memory, the generational memory, the waves, that's interesting, you know, to try to think back, right? So one could replicate, not exactly, but I think that in each one of these historical moments, one could see some feminists being more pragmatic and incremental, and some others being more radical and ambitious. And for, you know, I don't see, so the problem I see with the waves is that we might forget that there was tension and conflict, and right, and so different. So maybe this is something I need to, you know, the old and the new seems to be too much of, yeah, of two different moments, and not that it's happening at the same time. And I think in every country in Latin America, this is being replicated, and so that we have to think better. But I do sense there is something of the generational that's crossing with the historical, and that we have to think more. We have to think about it more. The constitutions are not enough. Huge. We could go on and on and on. But I think that at this point, one thing that I want to highlight about the Latin American feminists is that in many ways, they were never so enchanted by the Constitution. So on the one hand, they were obsessed with getting the equality clauses, but then litigation in many countries, they waited for 10 or more years after the constitutions were in place because they didn't trust the courts. So their strategy was in the legislature. So it was only in abortion that legislators were just very resistant, that they finally went to the courts. I don't know. I think that there's more to be said about that. I have my chapter on the Colombian Constitution in a book on women's rights in Latin America. It's exactly trying to explain why the Constitution matters, even if, like, we can see all these other indicators showing that nothing is better in the lives of women, right? So I am very sympathetic to your argument about the South African Constitution, but I think we need some more nuance. That the text is doing some things, feminists are doing others. Feminists in Colombia, in Mexico, and Argentina were very aware that one case was not going to win the whole war of women's rights and abortion rights. And, you know, this was like constant struggle against the waves of backlash, one could say. Dignity, I think that in the Colombian case, so we also have the dignity going towards the social and economic rights. But from very early, 1993, dignity also went the way of the good life in cases of use of drugs. So in 1993, the Constitutional Court declared that the crime of consuming drugs was unconstitutional, and so that individuals could carry drugs and could not be, prosecuted for carrying drugs. And we also have euthanasia from 1997. So dignity has also played a role in very strongly affirming like decisions over one's own life. So I think that life of dignity was useful in the abortion camp, even if it was not the one feminists would have preferred because of the Catholic undertones of dignity, as pointed out by Riva Siegel, for example, in her paper on this. So it wasn't very, not everyone was happy with the dignity. I was one criticizing the dignity turn. But yeah, it was useful in just representing to the very Catholic public that these were the extreme situations, that the indications were the extreme situations, so that they could not cut back. Because, right, they were trying to cut back gestational age, they were trying to reduce the exceptions. So the work of the feminists and the allies within the Constitutional Court was to say, well, dignity, this is not only about equality, is dignity, right? Which is, if you don't have dignity, you're less than human. So you're not even in the debate about equal humanity. You're in the debate about being a human or not. And so, dignity proved to be useful. It was also useful in highlighting that women were differently situated, and so that the poorest women were worse off, and so that the right to health, the right to bodily integrity, etc., should be understood in this light. In light of dignity. Yeah. Anyway, should we start with the?
Yeah.
Do you want to stand here, or should I?
A couple of sort of, I won't say rules, ways that we operate, norms, protocols. Thank you. So we have a one finger and a two finger rule, but we're going to start with the folks who are the students in the seminar, wherever you may be seated. And you can ask the first couple of questions. And if somebody asks a question with a one finger, a new question, and you want to jump in, you can raise two fingers, and I will call on you so that we can have a little bit more of a conversation. And if you know that you want to speak, get my attention now, and I'll start keeping a list, and I'll do that while Sue is asking questions.
Thank you for being here. I was just curious. So you talked about women's rights being very important in like all of these movements, and also talked a little bit about like dignity also being important. And I guess, I'm wondering to what extent has people like non-binary people been involved, and like we talked about like incorporating LGBTQ issues into feminist movements, and so we're just wondering like where have non-binary people been like left in this whole I guess in these movements.
Should I go ahead? So Colombia and Argentina have one of the most protective legislation regarding intersex and transsex persons and trans persons. In the case of Argentina, they don't see the connection to abortion, though the laws are from the same year. I mean, the FAL case, the FAL case, and the law on sexual identity in Argentina are from the same year, 2012. It was not necessarily a feminist achievement, but it was feminist friendly. Many of the people are just in both camps, right? But they didn't, they didn't act as it was an achievement of the feminist movement, but rather, like a justice issue. And there were very strong trans leaders of the mobilization. And in Colombia, there was also strategic litigation, but in that case was not from the feminist movement. It was mostly by clinics at universities that did the strategic litigation, mostly clinics at Universidad de los Andes, where I teach. But there's a lot of tension between the old feminists and some of the, and not because the old feminists think that they shouldn't have rights, but they think there are two different agendas, so that they should be fought separately. They're willing to fight them, but not, right? Yeah, this is like their, now that's the old feminists. Then of course there are people who claim to be feminists and act in feminist spaces and are against the rights of trans persons. But these are, so the old feminists that I'm talking about, in Latin America, I would say that as opposed to in other regions of the world, they're not against the rights of trans people. But that has been a big challenge, right? So, for example, in the latest exchanges regarding abortion, there is like big discussion of whether. So I think it is a Mexican judicial decision that says, like, the pregnant persons, right, that this is a right of the pregnant person. And so that was very much debated. So in Colombia, the feminists said, well, let's say women and pregnant persons. Let's not get rid of women in that formulation. And the trans persons who were in the feminist movement advocating for abortion agreed on that duplicity. I don't see in Latin America people working for abortion and what I've called here the old feminists as being in a confrontation with trans persons. They're actually willing to work together, etc. I don't see them either as putting a lot of energy into trans issues. So that's, I would say that's a question of, how we move ahead and what's going to happen with, yeah. Which I have also written about.
She didn't just come up with that. Okay, so I see Nancy, and I'm going to, and Marisol, and I'm going to, because you all didn't ask some questions last time, I don't think. You did. Okay, so let's go with Marisol. And then
Anita.
Olivia also. Okay. We can take a couple of questions if you want. Okay.
Thank you. So you mentioned that the subscribers to old feminism are themselves older and they're retiring, they're giving up sort of their NGOs or passing them on. So I was wondering, do you predict that that sort of old style feminism is going to be kept going by their proteges, or do you see it blending potentially with that sort of new feminism, or do you think that it should be blending to keep that sort of strategic angle going forward?
Should we take Nancy's question?
Oh, yeah. Well, I had Olivia.
I'm sorry.
Okay.
I just want to say before you start, that I have a number of students in here from my human rights class, too. Juicy human rights questions, so you all can do that. Okay.
Mine is about human rights. last semester I was in the Human Rights Clinic, and I was kind of struck by the use of the human rights framework in your paper. I didn't really realize this was such an effective tool to promote these agendas, and especially because I think, and I don't necessarily know if this is widely believed, but there's definitely a viewpoint of international law being somewhat ineffectual and maybe being hard to enforce. And so I was wondering, how do you turn international condemnations into actual change? And do you really need that intersection between the Constitution, like you had in multiple of the examples, and international law, or can you do it kind of just using that human rights framework, international human rights framework, without that constitutional interaction?
Mm-hmm.
Okay, and then Nancy, you want to get your question in?
My question is around implementation, because I feel like there's all this work either with strategic litigation or mass mobilization, but that there's sometimes a disconnect, like when it gets to the health system and actually like implementing whether the change is constitutional or legislative. And so like, how do we keep that momentum going once we get into the health system to actually have access to abortion for a wide range of people who are trying to seek that service?
Those are three small questions. You have 2 hours to answer.
Yeah. No, I think the question about the old feminism and, like what will happen with old feminism, I think it's a really interesting one. I don't think it's easy to predict. But I do think that there's on the one hand, like this feeling of success, like it really did work. And at the same time, it's like everything else is changing. So climate change, demographic change, authoritarianism. And so feminists seem to be, like the agenda in the 90s just doesn't seem to speak a lot because there's all this success, but then there's many other things that have not changed, right? So unemployment for women. So they have political participation, but they still have unemployment. I don't know, they're poorer. So that in the realm of the distribution of wealth, they performed very poorly, even if they were working for the poorest of the poor. So I think there's something like a big question, and now feminists in Latin America are very, very much working on care and care work and the right to care, and like this is, I would say, the next frontier. And I don't know, they're thinking of working on care using like the same strategy of abortion. I don't know. I think it's a very good question, Marisol. And I see changes, like everything around them is changing. So they shouldn't be, it's even one crucial thing, the donors are changing, right? So they're not giving them money for the same things they were giving them money for before. So this will change many things, I guess. But I still don't see how exactly. Human rights, international law. I think that in the transitions to democracy throughout Latin America, in Brazil, in Argentina, in Colombia, Ecuador, Bolivia, right? Probably the only country not having this was Chile. Having a clause on international law was like a big part of that transition. And here, some have argued that there's a connection with the anti-impunity efforts and then all the other human rights work, right? So that it was on the piggyback, so that the anti-impunity people were carrying over an idea of human rights that then could be used by others. So the mothers of la Plaza de Mayo, right? They're like this symbol of many things, but then also could be read as like the human rights, what you can achieve with So there's a lot of affect on the one hand, but then on the other hand, it's the anti-impunity and all that it has meant in terms of identity and truth, and what that means for reproductive and sexual issues, right? So you bring it from the war back into day-to-day life. So I think that was very important. So the constitutions do have clauses saying that international law matters. And the constitutions also have, which is important, that these constitutions have like very strong implementation mechanisms, like direct implementation, direct remedies, like to ask judges directly to enforce the Constitution. So you don't have to go through legislation, but you can go directly to the Constitution, which is something that was in the Mexican Constitution since 1917, and then degenerated in very strange ways that Mexicans can explain better. But the other countries use this idea, and it has been interesting. It's like changing people's relation to the Constitution in interesting ways. I don't think that everyone would agree on the importance of international law, but I think that old feminists have invested a lot on international law because of like this, like what Keck and Seeking, Margaret Keck and Catherine Seeking have described as the boomerang effect. So you don't get something locally, you go to the international court, and then once you get it there, you use it locally, right? So you have like a virtuous cycle. So the feminists have been trusting a lot this virtuous cycle. And we will have to see if in El Salvador it works or it fails. Because now the court might go into the hands of the opposition. So I don't know. I could say more about that, but I have to keep short my answers to the questions. The health system, what to do with the health system. So one interesting thing is that the feminists have worked a lot with the health system, and many of the feminists in the abortion camp were doctors. So they have been tinkering with the health system, and they have had, I think, interesting ideas about what to do with the health system. So they have not been at all naive about the need to keep the momentum going and work with doctors. So I think there's something there to be learned. But that's true. So there's been a lot of health litigation in Brazil, Colombia, and Argentina. Like beside abortion and outside of abortion, health has become this huge issue after constitutional reform. There was no patients' rights movements, etc., before these constitutional reforms. But after the constitutional reforms, it has huge issues for the courts. So for the feminists, actually, the question has been, should we use litigation to get abortions in the health system, or should we go for more structural changes, such as changes in education, changes in like the mentality of doctors, etc.? And I have a paper on one of the strategies with doctors. But I think that, that they've tried other things, and they're very aware that there's problems in the health systems. They have produced evidence on how cheap it is to have an abortion if they do it early. If they wait for an unsecure abortion, it would be much more expensive for the health system. So they've tried all sorts of arguments, like the financial argument, the time argument, etc. And the reason why they don't want to rely on litigation against doctors is that they think that, but I think they're right, that abortion is a very time-sensitive issue, so that if it becomes the rule that to get an abortion you have to go before a judge, you will never get an abortion. So they just don't want to go through that. There are cases we have in Colombia were litigated by individual women, it wasn't the feminist organizations, because it was, like a no-no in their strategy. But the women went on their own, and the court used the cases to build like a strong framework, but they that the health system has been they've been very aware of the need to transform the health system. Some would say it's too incremental. These health systems are there's huge inequalities within the health systems. And so just tinkering with access to abortion will not make a difference for women, etc. Yeah, that's true also.
Let me just see, can you raise your hand if you think you might have a question at some point? Okay, why don't we take a few from a different class? No, but actually, we'll start with you. You're not in any of my classes.
That's correct.
I didn't even know there were classes required to be here. I wish I could signpost this question better, but my thoughts are kind of all over the place. At the beginning of your talk, you talked about, in Mexico, kind of the strategic work of the early feminist movement with being in the streets on times that the legislature was in session, considering bills decriminalizing abortion. And I was thinking that, yes, it is true that the feminist movement in the U.S. has a lot of strategic planning to be desired, but even if they were the most strategically planned thing ever, I guess I just kind of lack faith in our legislature and court even to be swayed, I guess, by that strategy because of the religious makeup of our legislature and our court and their inability to separate church and state, despite that being in our Constitution. And then I was thinking about Mexico, which to my knowledge is demographically, quite Catholic. And so I'm curious kind of how the strategy of the feminist movement was able to overcome, I guess, to my knowledge, that, the general Catholic view of abortion. You talked a little bit about the dignity argument. I don't know if that in and of itself was enough to sway, or if it was the representation of women in the government, which you also talked about there being quotas in a lot of Latin American countries, and we don't have that here. But yeah, I'm just kind of curious if you could speak to, in general, and maybe this term is US-ified in and of itself, the whole separation of church and state thing, but how activists were able to overcome what I assume to be a general religious viewpoint that would not support decriminalizing abortions. Hopefully that question made sense.
Okay, so we'll get a couple more, Jeremiah and Liz. We only, depending on how, let's say we have 10 minutes. I had a question. I might throw it into, yeah.
My question was about international human rights law. I noticed that most of the cases that you mentioned said that it was against international human rights law to make these, the laws were against, it was making abortion illegal. Mm-hmm. Is there any international human rights laws that make sure that it's widely accessible and give states more obligations?
Mm-hmm.
Great. Liz?
Mm-hmm.
Hello.
Hi.
I'm not super familiar with all the recent developments in Chile with the Constitution, but I am more familiar with organizing, at least in a domestic setting. And I think I'm curious if you could speak to whether, I really don't know, whether potentially the goal might have been less to achieve a constitution that included these clauses around abortion rights, and maybe perhaps more to use the moment as a stage to have a conversation that would force, at a national scale, a certain political discourse that could then be channeled into other wins, maybe at a local setting or something like that. That's just something I'm curious about.
Okay, so if you can get those, maybe we have time for one more round.
So church and state. So first, just to go back to, it was in Argentina where they were able to get the masses into the street. Mexico, they're very good at organizing, but as far as I know, because it was, many things were different. So Argentina, it was Argentina. And actually, for Argentina, it was a quite interesting and difficult scenario because many of you may know that the Pope is from Argentina. So Argentina, which in many ways is secular and believes on this, actually no, they don't have separation of church and state. Actually, the Argentinian state funds the Catholic Church. So how were they able to mobilize and achieve this change in Congress, right? So they didn't do it through the court, which was more conservative, but in Congress. So what I know from my Argentinian friends, or their own argument, which I haven't seen written down, but was that they were able, since 2014, to persuade the leftist but technocratic legislators, both in the House of Representatives and the Senate. They also have a two-camera thing, two-chamber. They were able to persuade the women that they should act as a caucus, so that they should act together, that abortion was above partisan dispute. And so the women caucus was the one that was able to approve the law. And apparently they went over any objections based on religion. I think the people out in the streets might have helped in giving the impression that actually the people, even if Catholic, agreed with the decision, and this is why it was so important. So as they explained, they had to have all the key in 2014, the key to getting the House of Representatives to approve the bill was to have it approved in the last minute. So they had to, there was like a, I don't know the technical term, but they had to wait and wait and wait to vote at the very last minute. And so they needed the people to sit out for the whole time so that while they were negotiating back doors and listening to the discourses and they were negotiating back door, they could say, well, look at the people in the street, and they're not going to bed until we vote this, and we won't vote it until we have the votes, right? So that's why the people were crucial. And I guess it helped to overcome the notion that the Catholics would disagree, because there were many people in the streets. So whether international human rights law imposes a duty on states to decriminalize abortion in general, I think some would argue that. Yeah, so there's papers written on, it's not really true, and this is just an interpretation, etc. In the cases brought by Latin American feminists, what the different treaty bodies have said, and then the treaty bodies, they have said that to submit a girl to X treatment when the country allowed for the abortion, right? Because one has to remember that in Mexico and in Argentina, there were exceptions. The problem was that the doctors were not allowing women to use the exceptions. So it was legal. What the girls in these cases were trying to do was legal. So the committee bodies didn't have to say that abortion was illegal. They just had to say, implement the law, and when you don't implement it, you violate rights of women to equality, you submit them to torture, etc. Then again, I think it's different for the Inter-American Court, which might be, I trust, they might say very soon that the Inter-American Convention on Human Rights does demand decriminalizing abortion, at least in some cases. So, but it hasn't happened yet. I hope it will happen soon. In the Inter-American system, though, even the most progressive judges do not want to make the argument based on the right to health. So accessibility will remain outside of the legal duty that is imposed upon states, if this happens, because it hasn't happened yet. So I think that's a good point. And feminists are very, concerned about how to move ahead in this scenario. But as I was mentioning, they see it as so difficult politically in some countries, such as El Salvador and Nicaragua, that even if they get from the court a very minimal standard of decriminalization, that is better. So in El Salvador, there is no exception for abortion. The Beatriz case involved a woman who was kept, I would say, a prisoner in a hotel room because she might die from her pregnancy, and the doctors were not willing to give her an abortion, although many authorities, including the Minister of Justice, gave them the order. And they would rather put her in a hotel room to monitor her vital signs than allow her to get an abortion. They kept her there like for 3 or 4 months until she gave birth. So in that situation in El Salvador, like this incremental change allow for abortions in case of risk to health or to life. That seems like huge progress. I think that other countries have locally more, local legislation is more favorable, allows like more room to wiggle than international law. So you have more at the local level than international. So most of these new constitutions have the right to health enshrined, and there's all this. In Colombia, the right to health is a fundamental right. So you can go before a judge, any judge in the country, and ask for a medication if for some reason doctors or pharmacies are not giving it to you. It's not ideal. But, yeah. Use this scenario to open up the debate. Maybe, but we haven't seen yet what's happened. I mean, I think that in other cases, one could see how like big ambitions are very useful to open up debates. In this case, we haven't seen it yet. So we haven't seen what was the strategic goal that the feminists were trying to achieve. So I have to say, so some of my friends are the old feminists in Chile, and they were very concerned. They really believed in constitutional change, my friends from the old feminism. And I think that in many ways they perceived that these ambitions of the younger feminists, who ended up being the members of the Constituent Assembly, because the old feminists could not. Like the average age of the Constituent Assembly in Chile was like 32 years. And so the old feminists were left out. And they had to come in at a later stage of the process in Chile to just try to savage, right? And I don't think at any point they said it was wrong, the young, they spoiled everything. But I remember my friends from the beginning saying they really trusted that the Constitution could be reformed. And it was just, they kept saying, well, so I'll tell you something very short about the Chilean Constitution. From the beginning, they knew that the Constitution they approved had to obtain 2/3 of the vote of the general public in an election that for the first time in Chile had to be, it was a mandatory vote. So everyone had to vote. So the call for the Constituent Assembly was under these conditions. So when they created the Constituent Assembly, they knew that whatever they decided would then be voted by the general public in the first ever mandatory vote in Chile. So my old feminist friends from the beginning were saying, Isabel, how do we negotiate this? Because we really want the Constitution, we really want this constitutional change, but 2/3 of the general public, that's a very difficult standard. So maybe the younger ones thought, we're never going to get the Constitution. They've already set an impossible goal,
So let's just ask for everything. Maybe they were thinking, as you are thinking, like an organizer, let's ask for everything, because no matter what we ask for, we're never going to get it. That might have been the thought of some. But for the old feminists who thought that the constitutional reform was really crucial for the country and that they needed, because there had been these social protests and the leftist party had been trying to reform the constitution. It was the Pinochet constitution, etc. So the old feminists really thought that it was important to change the constitution. And it was, in the end, it was frustrating to not get it. There were several rounds of debate, and it was very frustrating that nothing moved ahead. So but I agree with you that sometimes you just open up the debate, even if you know you're going to lose. And that might be the best to do with some opportunities.
We've been challenging you a lot. So these are terrific questions. The paper opened so many. Nettle hit about a third of the issues in the paper. Very provocative. This is the second great discussion we've had about it. I'm just going to suggest that it's very funny because we decided to end these a little bit earlier, and it's hard because there's a lot to talk about, but I'm going to stick with that halfway. And I'm going to invite Anita to come ask you the question. I'll ask you my question. And others should come hang out until you have to teach your class in 20 minutes. But I just want to thank you again, Isabel. I want to thank Neville, and not just for this moment, but for the provocations that I know will continue to affect our thinking about these issues. So.